Okay, I apologize, Mr. Chairman. Should be good to go now.
You announce the meeting or are we okay?
You
I
might.
don't know how much you got.
Go ahead.
Just make sure you all got recorded. Call to order the Tuesday, June 24th, 2025 meeting, of the City of Oxford Board of Zoning Appeals to order. Please call the roll.
Mr. Wyatt.
Here.
Mr. Chapman.
Here.
Mr. Destor.
Here.
Mr. Russo.
Present. Next order of business is approval of the January 28th, 2025 minutes of the regular meeting. You all have them in front of you. You've had a chance to review them. Is there a motion to approve? So moved. Is there a second? Second. There's a second. Any discussion, any modifications, any suggestions? Hearing none. All in favor indicate say aye.
Aye.
Opposed? Minutes have been approved. New business, BZA 2025-01, 124 Pin Oak Drive. Two variances to section 1143.01 C to B minimum rear yard depth. And section 1143.01 C 2C minimum side yard width. Applicant is Mr. Kiger, agent is Scott Webb. Please, Mr. Webb. Thanks. Back, I'm sorry. Go ahead.
No problem. Thank you, Mr. Chair. Good evening, board members. So this is our first case of the year, believe it or not. This is BZA 2025-01. This is a set of two variances for 124 Pin Oak Drive. And please feel free to turn your attention to the screen. So some basic details on the application. Again, the applicant is Scott Webb, architect, who is representing the property owner, Alan and Marty Kiger. Of course, Alan Kiger is with us this evening. The current zoning of the property is R1A, single family, low density residential district. Current use of the property is a single family dwelling. And the proposal is a request for a side yard setback variance and a minimum rear yard setback variance. And these both are sourced from the same section of the zoning code. This is section 1143.01 C2. And here is a map showing the location of the subject property. This is adjoining to the Oxford Country Club to the west. And then a look at the zoning classification in the area. It is all within the R1A single family district. Okay, so just a general timeline to share just to get things kicked off here. So we received the first building permit application back in February. So on February 7th, the project scope had included a number of things. The first thing was a carport conversion to a two-car garage and new covered entry in the front. So effectively a small front porch or front stoop. There is a covered porch extension in the rear, a new deck in the rear that has a pergola overhead, as well as an interior remodel, new master bath, kitchen remodel, etc. So the zoning review was returned the same day that the application was received, 2/7. Unfortunately, it was denied due to the deck element encroaching into the required rear yard setback, which was a distance required of 40 feet. So at that point, it's kind of in the applicant's court to return revisions or request variances. So what ultimately was decided was to submit for a second building permit application that reduced the scope down to just the interior remodel only for the bathrooms and kitchen. That way they could receive their approval for that particular part of the scope. So the second building permit was issued April 1st. And then on April 24th, we received the subject variance application. At the time that the application was received, a property survey was included with the application, which revealed that there is also a side yard setback issue in addition to the rear yard setback issue. And I'll explain that in a little bit more detail here in a second. Do have some site photos provided from the applicant. So this is a front view of the property showing the existing carport. And then here is a rear view, and we can certainly return to these as needed. Then here's some views from above. Hopefully I got the holes correct. So there's hole number 8, the green, which is a par 5, and then there's the tee for hole number 9 across the pond, par 3. So the tee for number 9 is essentially adjacent to the subject property, which is highlighted there in yellow. So again, this is 124 Pin Oak that we're talking about. So 122 is to the south and 126 is to the north. So this is effectively a dead end street. So looking at the side yard comparison, so probably a more typical side yard setback to the north. So it's about 20 or so feet to the northern property line on the subject property, and then another 28 feet to 126. So that it totals about 48 feet or so in between the houses. There's quite a bit more distance to the south, about 88 feet in total, of which 21.8 feet is attributed to the subject property and the remaining 66 feet is attributed to 122. Okay, so looking at the relevant zoning code provision, so this is out of 114301C2, provides the following setbacks. So it's a minimum front yard depth of 30 feet, a minimum rear yard depth of 40 feet, and a minimum side yard of 10 feet. So the two variances that are needed, one for the 40 feet in the rear, one for 10 feet on the side. And there's additional language in 1141 that clarifies that any deck is subject to the district setbacks. So unlike a patio, which actually is not subject to the district setbacks, is subject to a lesser rear yard setback of 15 feet for a patio. For a deck element that is constructed against a home, it is subject to the district setback of 40 feet. So that's the part of the language there that says district setbacks are applicable. Okay, and then here is the survey that was provided to us as a part of the application. So you can see the house is presently set back 45.3 feet. So it is compliant with that 40-foot setback. And then there's also a distance of 21.8 feet to the south. So of course, complying with the 10-foot setback as well at present. Here is a look at the submitted plot plan from the architect. And looking first at the rear yard setback, so the 40-foot line is drawn there in blue. And the proposed encroachment into the setback is shown there, 31 feet 4 inches, shown in orange. And then here is a look at the side. So you can see the 10 feet marked in blue and the proposed at 5 feet 6 inches in orange. And then here is a look of what the front elevation would be upon completion of the project. So you can see the 2-car garage. So the carport would transform into a 2-car garage. And then here is a look at the side. So here you can see the covered patio right here. That element is visible. And here is a look at the rear. And again, we can refer back to these as may be needed. And then looking top down, so this is a floor plan view. So all of the interior remodel is contained to this area here, as I understand it, in terms of the reconfiguration of the walls and so forth. So the new expanded footprint areas are shown here in orange. So in order to accommodate a 2-car garage versus a 1-car carport, has to expand to the south. So the south would be to the left side of your screen. And then to the west would be the upper part of your screen. So this encompasses the enclosed porch as well as the deck and pergola elements. Okay. So now we're ready to review the decision criteria. So in accordance with section 1139.02C1, the burden of proof is upon the applicant to present reliable and substantial evidence that supports the request for variance. Furthermore, per section 1139.02C2, the BZA must find that practical difficulties exist that would render strict application of the code unreasonable. In determining whether practical difficulties exist, which are sufficient to warrant the variance, the board must use these 8 decision criteria A through G. So going through each one of them, criterion A, we actually rated this as mixed evidence. This is whether the property in question will yield reasonable return or whether there can be any beneficial use of the property without the variance. The land use of the subject property is not in jeopardy with this request. It is already a single-family dwelling and the property is zoned for single-family use. So the existence and occupancy of this dwelling constitutes sufficient evidence. There's already reasonable return. However, we decided to rate this as mixed evidence because we do feel the applicant's arguments regarding the conversion of an antiquated carport feature to a more modern garage amenity do warrant some merit with respect to increasing beneficial use, marketability, and value for the property. B, so for variance number 1, which I'm categorizing the rear yard setback as number 1 and the side yard as number 2. So for rear yard number one, we find that B supports the variance. So the subject lot, given its smaller size and shape, it's actually more reminiscent of a lot that would be in a denser zoning district, say the R1B or the R2A, as opposed to the R1 or as opposed to the R1A. Rear yard setbacks are typically less in those districts, requiring 35 feet in the R1B and 30 feet in the R2A, respectively. So for these reasons, we feel a rear yard setback distance of 31 feet plus 31 feet 4 inches, which meets 78% of the required R1A distance of 40 feet. We feel this is not substantial in this case. The side yard setback, however, it's 5.5 feet, so that's 55% of the required distance. So from a numerical standpoint, we do believe that's substantial. C is whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. We agree with the applicant's findings. We don't believe this is going to substantially alter or negatively impact the essential character of the surrounding neighborhood. This is a more estate style feel to this subdivision. And especially given the incredible amount of distance between the neighboring property to the south and this one, we feel there's no merit to criterion C, so we feel it supports granting the variance. D, all of our city departments returned this application, no comments, so we don't feel like governmental services will be adversely impacted. So D supports the variance. Criterion E, it's a no on number one and a yes on number two. So this tries to get at whether or not the variance is provoked by a self-created hardship when you're talking about when a property owner purchases property with knowledge of a zoning restriction, prior knowledge of the zoning restriction. In other words, an owner that purchases property who knows full well that the zoning regulations restrict or prevent what they intend to do should not expect a guaranteed outcome. Of course, they can still seek the permission to do so. We didn't really find enough information in the application to determine the criterion E one way or another, which actually doesn't match the slide there. So I do apologize. Criterion E should be undetermined. So it's neither an X nor a check mark. But you may ask questions of the applicant, or the applicant can contribute evidence toward that criterion. Criterion F is mixed evidence. Evidently, I didn't update the slide as I should have after I wrote the report, so my apologies. Criterion F is mixed evidence. That is whether the property owner's predicament feasibly can be obviated through some method other than a variance. So the predicament at hand is the owner wishes to construct new amenities on the property which are coming into conflict with the city's imposed setback limitations. As the applicant states in their application, the requested variances are truly necessary in order for the features as proposed to be constructed. There's no alternate location or method for kind of getting around those standards. The only other option would be to diminish the size of the deck or eliminate it altogether. And then in terms of the garage feature, likely this would entail possibly downgrading the garage to hold one car instead of two cars. So we rated criterion F as mixed evidence. G is correct on the slide. We do feel that G supports granting both variances. A little bit of history with this one. So G is getting at whether the spirit and intent behind the zoning requirement would be observed and substantial justice done. So I think it's fair to mention, so this subject lot is part of a subdivision called Fairway, initially recorded in 1955. And as the applicant notes, the house itself was constructed in 1957. It adjoins the Hill and Hollow subdivision to the east and to the north. These were initially developed outside of the city of Oxford corporate limits and then later annexed into the city in the 1960s. So therefore, at the time the property was first conceived, it wasn't subject to any city-specific zoning restrictions. And with a lot size of 13,000 square feet, again, it's not typical of standard R1A lots that require a minimum of 15,000 square feet in size. In terms of setbacks, the only thing that the 1955 plat dictates is a 40-foot front yard setback, what's referred to as a building line on a recorded plat, which is actually 10 feet greater than the 30 feet that would normally be required for R1A. So All of this is to say, in this particular case, staff feels the standards of the R1A need not be treated as the end all be all with respect to lots in Fairway, inclusive of this subject lot at 124 Pin Oak. We do believe substantial justice would be done by granting both variances. And I have nothing further to add on this application. I'm happy to take any questions from the board members.
Just.
Any questions?
Yeah, I did ask that, the property owners, joining property owners were notified.
Yes, surrounding property owners were
No,
notified.
no
We did not
objections.
receive any phone calls, emails,
Especially
communication.
the one that's gonna, on the garage, that's gonna.
Yes,
get
they would have been part of that.
Even if
they're
there's,
okay.
even if there's a substantial area, there's still a huge amount of, I mean, I know there's a thousand playing off of it, it's a decent. Footage.
My understanding is that Stevenson's had no objections.
Their neighbors.
I spoke with all the neighbors, provided them details. But the one thing I didn't do is I didn't specifically say to accept or reject. Because as friends and neighbors, I didn't want to put somebody on the spot to have to reply to me. And I let them know they would be getting notification from the city, and that's a nice way that they don't have to, if they didn't like it, they don't have to say it to my face. So I can't say positively, but Ned.
But Ned was notified.
Yes. and I
They
met with-
didn't file it.
I met with every property owner.
That's all I.
That was my understanding. Any other questions for that?
Actually, I think Alan wants to start us off here.
So can you go back to, yes, that one. So for those of you that don't know me, I'm Alan Tiger. My wife and I purchased what might be the homeliest bungalow in Oxford. And doesn't even have a front door. So you might ask yourself, why did you do this? For me, it's aging in place. I'm in my 70s now. I have a beautiful house, big, got porches all the way around it. It's over an acre of land, creek running through it. A lot of maintenance, a lot of upkeep. So I'm now trying to be proactive instead of going, okay, something happens to me, my wife can't take care of this house. Something happens to her, we're gonna have to look for something smaller. I want to be proactive and start to think about, okay, where can we go? So why did we pick this thing? I gotta laugh because the reason is it's small. It's 1,300 square feet. All on one floor. The reason I picked it is small lot, 1/3 of an acre. More to the R1B size. Single story. But one of the main reasons we've selected this house to try to age in place into is the uniqueness of it. In and around town on Timothy, Devonshire, there's a bunch of brick ranches, smaller single story. This, believe it or not, has character. It's got an open floor plan. It's a mid-century modern. So we want to keep it that mid-century modern. I want to pay tribute to that. It's been tough for me because I currently live in a farmhouse style and I'm more comfortable in a cottage, but we've been trying to keep the mid-century modern going. Our plans are, this currently is 3 bedrooms, 2 baths, sort of, bath and a half, with no bath attached to a bedroom. Old school. So what we're gonna do is we're gonna convert it to 2 bedrooms with 2 full baths. And that way it's gonna be more comfortable. We're thinking empty nesters like ourselves or young professional type of house. Probably this size house isn't going to appeal to young families with 3 or 4 kids anymore. The porch addition. We are big porch people. We have 3 porches on our current house. Large front porch, covered side porch, large back porch. So the porch is really important to us. And one of the other things about the porch is getting back to this aging in place. We can do a patio. Down 1, 2, 3 steps. That kind of defeats the aging in place part of it. So what we want to do is do a patio all the way across here. Again, let us step straight out from the back of the living room onto the patio. The other thing about the patio, when I first looked at the house, I looked at the neighbors. Two of the neighbors both have additions on the back of their house, which go out. Later, I measured it, and one is there's only 32 feet of rear yard on one, and only 36 feet of rear yard on the other. I came up to the city building, and he was here, and Sam, and said, "Are there any BZA cases for these houses on Pinnet?" Well, there were none. I said, "Okay, well, it must be okay." So that's kind of where my knowledge was on putting a patio on the back. Both my neighbors have extensions on their house. On the garage addition, that's our blunder. When we looked at the first survey map and the first plat, it looked like the building was right in the middle of the property, and it's not. When the final survey came in, it's off by 5 feet. That's when we notified the city, we're off by 5 feet there. I guess in summary, it's all for us aging in place. Actually, my house is 3 doors away from this house. And so my one thought is, if it works out, my kids take over my house. My grandkids are now 3 doors away. They're in the big house. We're in the little house. But I can't guarantee that's going to happen. The final approval of this is my wife. If she likes it when we're done, we're moving in. If she doesn't like it when we're done, we may have to sell it. So I can't guarantee you that we will be the ones living in there. But what we're trying to do is save it as a mid-century modern and try to adapt to what we think an empty nester like ourselves would want. Scott is the technical guru, so he's got all the stuff on how it meets all the criteria. So I'm going to turn it over to him. I just want to give you a feel for where we're at on this. Or if you had any questions for me directly. Okay, thanks.
Just use the arrow keys to copy the slides. Good.
Okay, so this is kind of a little rendering view of what we're looking to do here. As we're all aware at this point, we're looking for 2 variances, both to 1143-01C2 for the garage and the deck addition. The garage is obvious on the right-hand side there. The porch extension brings it out just past the house, and we don't need a variance for that one. That one is within the setback. So as far as the rear yard goes, we're really just talking about the deck. And Alan and Marty have this idea of using a pergola. One thing that I thought Alan was going to mention that he didn't is the sun is brutal in this house. This house faces due west. You see from the pictures, it's 100% glass across the back. We either shade it 100% of the time from lunchtime on, or you just deal with a ton of sun. So we looked at a lot of different options, a more physical addition, like an extension of that existing roof, perhaps. We looked at maybe doing, we did some shadow studies about putting hedgerows back farther in the property to see if that could shade it, but that would obviously take most of the view as well. So if you, there's a slide later here, you'll see there's companies that make these pergolas that have louvers on the top, so it's still open, you get lots of air, but the louvers do what we want them to do and keep the sun off the glass and hopefully solve some of their overheating problems there. So here's a site plan addressing the setback areas. We'll start with the side yard setback. The survey came after the drawings. We had started the drawings, knew what we wanted to do, like we do in the modern world. We go to the county GIS and try to see how close we are. We thought we were within a foot. Turns out we were not. When the survey came back, the house is a little farther to the south than we had imagined. Nonetheless, I'd like to spend a minute talking about the point of side yard setbacks. The point of the side yard setback, I believe, is to create a reasonable rhythm of facades along the street, and also to protect your neighbors. So having a 10-foot setback, a 10-foot side yard setback should effectively guarantee you've got 20 feet to your neighbor, with each of you having a 5-foot setback. As the survey pointed out, we have lots of room to the north from the side yard side. from the south, yes, we are taking 5.5 feet of the 10-foot setback. But what's interesting in this neighborhood, maybe Zach can answer this for us. We have no idea what is Ned's front yard, side yard, rear yard. It's really hard to say. The house is kind of crooked, but the point of it is that the result is that we have 80 feet right now between these two houses. And so we feel that, yes, asking for 5.5 feet out of 10 is substantial, but asking for 5 feet out of 80, is not. So we feel that the spirit intent of the zoning code here to provide separation and protection between your neighbors is certainly accounted for. As we look at the garage as it is right now, the picture you saw at the beginning, not only is it an antiquated carport there, literally the front door is at the very back of the carport. So strangely, you enter the house at the rear of the house by walking through the carport to get there. So the idea of the garage then was to spread that open, to bring the door forward a little bit, to give it a little more presence from the street, have a nice entry. We have some new closets and things in there. So it just kind of, helps the house in a lot of different ways, not just the functionality of the carport, but also just street presence, welcoming entry, all the things that. So. Rear yard setback, similarly, the rear yard anticipates 40 feet from each side, meaning you would theoretically have 80 feet between you and your neighbor's house. We currently have 343 to the deck of the country club. So, we feel that that's simply not an issue. The issue perhaps would have been from the other direction, that the Kiegers should be more concerned about the noise from the clubhouse than the clubhouse should be concerned about the noise from the Kiegers. That's how that one works. So regardless, even without this particular description, staff agreed that this one is not substantial, that we're providing 78% of it. And then, like I said, as we go further and look at the actual separation of buildings, which is what side yard setbacks are about, or rear yard setbacks are about, we're way over 343. Likewise, the neighboring properties provide smaller setbacks. The property to the south, Stevenson property is only, I don't know if we call it the side yard, it's 33 feet from, or the rear yard, it's 33 feet 8 from what we're considering our rear property line. The two houses to the north are 36 foot and 32 feet. And so we feel like, it's just another reason why this is not substantial. And then again, a nice picture of the sun beating on the windows there, and a picture of the proposed pergola idea that shows how that's going to help us keep that. Those pergolas actually have adjustable louvers so that they can kind of determine the amount of shade. And keeps
Is that the actual style?
Yeah, there's a company called Cincinnati Pergola Company. There's a lot of people that make it. It's becoming a fairly common design. They're kind of a set. They're like a modular setup, and you can get them motorized or hand cranked or whatever. But yeah, it is a structure for purchase. It will sit on the deck. It doesn't require its own foundation or anything like that. It's lightweight, but obviously sturdy. It's anodized steel. So that's kind of the info there. And so with regard to the decision standards, so I think replacing the carport with the garage and improving the entry increases the beneficial use of the property. Not to say that it has no beneficial use, but I think this is definitely an improvement. Whether the variance is substantial, my point here is looking at the purpose and intent is, I don't believe that the side yard setback is based on the idea that you have to have 10 feet from some property line that you can't even see. It's based on the idea that we want to make sure we have 20 feet between buildings. I mean, you would be hard pressed to tell me where that property line is, look out there. So in that regard, we feel like we are meeting or exceeding what the code is intending or the code is implying. It's really about the separation of buildings, not the separation to an arbitrary line on a map. So That's why we feel that one is not substantial. We feel the essential character of the neighborhood would be improved. There's been lots of work on these houses since the 50s. Most of the neighbors have done additions. Many of them to the rear that are having setbacks like we're asking for. So I don't think that's a real question. I think the Tigers have done a beautiful job on their house. I'm sure they're gonna do the same as we make our way through this one. So delivery of governmental services, I think that one's pretty clear. You know, everything is in place, utilities are there, so nothing to worry about there. Whether the property owner purchased property with the knowledge of the zoning restriction. As I said, the exact location of the home is not really known until the survey came in. So like I said, we kind of thought if we were close, we could shave a foot or two off the garage maybe, but 5 feet would make it not a 2-car garage. And so decided we'd pursue the variance rather than just trying to trim it to something that was unworkable. Alan had kind of pointed out too that, and you can see from this slide, you know, if you look at the neighbor's house, I mean, we're not, you know, they're farther back than we are, so it was reasonable. And with Alan's request with the city to ask if any of those people needed a variance, apparently not. So it's reasonable for him to assume that he could probably do something because all of his neighbors did. So, and then with regard to the rear yard setback and the knowledge, we kind of went back and forth with the idea of doing a patio instead. And like I said, we did some shadow studies to see if there's anything we could do with vegetation or a freestanding trellis in the yard or something like that in order to do it. It just didn't really work that way. So, if you recall from some of the earlier pictures, there's also some basement windows along this backside. So by putting a deck on there, we're going to put some kind of translucent panels so we can still try to get some light into the basement. Whereas if we were going to pour slab there, we would be pouring over it, essentially losing all the light in the basement. So that's that. Whether predicament can be feasibly obviated through some method other than a variance. The variance is just necessary. The side yard variance is necessary for the improvement of the entry and to provide the 2-car garage. The rear yard variance, you know, you said it theoretically it could be a patio instead. I'm not sure if the city's ever dealt with this freestanding pergola, if that's a permanent structure. I don't know how we see that as it comes down the pike later.
And that's sitting on a deck.
Yeah. But the deck, it's the deck we need the variance for. I'm
Right.
saying, I don't know, if we set that on a patio, we wouldn't need a variance for the floor. But maybe we'd still need a variance for the pergola. I don't know. It's never come up. So, and then finally, we believe that the spirit and intent of the zoning requirement would be observed. Substantial justice done by granting the variance. As Zach pointed out, and as always, we appreciate the thoroughness of his review and his research here. Yeah, that this entire property was developed prior to it even being in the city and clearly predates current zoning code. So, you know, it's another situation where we have, from the day we assigned zoning, we've made the property not conforming in some way. And it's already too small for the district that we called it. So, you know, all of this stuff sort of predates the zoning code. And thereby we think that can still provide the separation between the buildings that the code implies and fit nicely into the neighborhood without any detrimental impacts to the neighbors. You have to answer any questions? Good.
How big is the new garage? What's the dimensions?
That looks in there.
I think Zach had a pretty good idea.
Typically 24 by 24.
24, but, and what's the existing, carport size?
About
10. So this is going to be another 14 feet or so over from the existing.
Yeah.
carport. Now, the second question I had, I don't know if Mr. Bernard can answer this. Are we gonna set a precedent by doing this? If we go up to 5 foot on side yard setback, are we gonna, I'm concerned about that. I think this is good. I'm gonna vote in favor of this property, but I'm concerned about the precedent.
I don't believe it's a precedent. I take every case as an individual case, given the specific elements of the case. This is a purely residential,
No, I see it.
uh,
And the 80 foot
Situation.
between the houses, that makes a big difference.
no traffic,
Yeah.
implications.
But
Correct.
I
Governmental
think to your point, Mr. Chaffin, is that, you know, each case has to be settled differently. I mean, if the property to the left was at 10 feet, we were asking to take 5 of ours,
That would
that would
be-
be a different case
yeah.
entirely. So,
Okay.
you know, the precedent when you, hopefully, as you vote for this, when the motion comes out and you reflect the decision standards, you know, that will protect you from precedent and saying, we believe this one is unique for those reasons.
As a minor concern.
Well, and here's how I would answer that question. The BZA, you are fact finders, and you make the determination of whether or not you've determined facts of a given case are unique enough that substantial justice is met if you were to grant a variance. And so the weight that you give a factor is purely the weight that the body gives. Property built before outside the city, annexed in, wasn't built to code, all of those things become factors that you would determine the weight of based upon the evidence that's been presented.
So I have a couple of questions. Arnold Tool built this house, correct? Yeah,
Tool.
yeah, and then Joyce,
Right.
Joyce,
It's been in one family.
I was gonna
since
say, you're really
1957.
the third owner and
Right.
only the second non-tool family owner.
I'm saving the door with every child's height on it
Yeah.
for
Yeah,
them.
Yeah, they got a mark on there.
Yeah.
Oh, that's cool.
the house, the property directly north with the addition. How much further does that addition go past where your deck is gonna go?
So I went out and measured.
It's about even?
We're asking for
And that's an
31.8.
entire structure. I mean,
Yeah.
that's not a,
We're asking for 31.8 to the deck. I think they're at 32 feet.
Right.
no,
they're
I'm
32.
very familiar with this.
Yeah.
This property. And the location. And again. We have no complaints or any responses by property owners. Adjacent across the street. Yeah.
Can I ask a general question? The 10 feet rule or the setbacks in general, the original intent of that zoning specification. What's the point of that?
I think Mr. Webb put it really well. When you have a typical rhythm along a block, when you have standard lots with frontage only on one side on one street, it's essentially mandating a minimum separation between,
So the
between the
not two
structures.
houses get too close.
so
to
they're
each
not
other.
too
Right.
close to one another, so there's
Is
adequate
that an aesthetic?
light
thing,
and
or-
air. Yeah, it goes into the aesthetics of the neighborhood.
This particular property,
Yeah.
the side
Yeah.
setback
Yeah.
really. Next to Stevenson's. I mean, it's really not even their side yard, it's the way Stevenson's placed their house on that corner piece.
They'll get to look at the side of my garage
All right,
instead of looking at the
right,
garbage cans and things that are in the carport. So it actually will aesthetically probably be better for
but
them.
again, they
Plant trees.
provided no
I see.
complaint
Got
or
some
any
trees there,
response to
so
your
it's-
notification. And next door, Country Club didn't either. Any other questions during the evidentiary portion of the hearing? If none, we'll close the evidentiary and go to a deliberation.
Well, so currently, if you wanted to deliver the quasi judicial process, you could deliberate privately. That would require a motion in a second. However, if based upon the questions and what the body may choose to do, you could consider a motion to adopt the findings of fact. I mean, there's, Bill, this is kind of,
Right,
you're familiar with the process.
Yes.
And at the end of this, I've got something that we're gonna be talking about as a body, the
yeah,
recommendation.
the issue is, under several court cases, including the Ohio Supreme Court, it's a quasi judicial body. The Open Meetings Act does not
Apply.
apply to us in the sense of deliberating in public, we're allowed to deliberate in private, it's not an executive
And then
session.
come out and then announce
Yes.
it, and that's a decision.
But practice is policy, for several years now, and as a consequence.
It's long before I.
As a consequence, the practice has been to deliberate in public. But I think we're at the point where we'll probably be providing notice that deliberations will more than likely occur in private as a result, so not to surprise anyone now.
As it relates to the agenda, when we get to the end of this, I'm gonna make some comments related to that
Perfect.
before adjournment.
Perfect. Okay, so deliberation, questions, comments, concerns?
I just want to say, of all the cases we've had so far, this one seems to be the most justifiable in terms of granting the variance, because just the unique design of the project and its location to the other properties, we're not gonna really be expanding anything major. It's pretty minor variances as far as I'm concerned, especially the back deck.
Yeah.
And the only concern I had was about the garage extension, and if it's not gonna set a precedent, then I would move that we adopt the variance request on both aspects.
I have no problem.
Okay, I also don't have a problem. In fact, I find that it's, I mean, this is one of the more desirable pieces of property in the city of Oxford in terms of its location and it's being enhanced in a way that's gonna, I think, improve it, you know, but for all parties, all the neighbors. I do find it interesting that the additions on the properties, the two properties to the north, never were subject to a,
Yeah, I did not research those, so I'm not sure the circumstances or when those additions were done or.
I just, like I said, it's really not relevant to us here. I just found that interesting. So I myself, don't have a problem with this, but we're gonna take each variance separately and not combine it as one. So, Matt, do you have any other questions?
No.
Walshy, we're good? Aye. So do we have a motion for the granting of, we'll take variance number one, which is the rear setback for the deck, pergola.
I would move that.
Steve moves granting of the rear, variance number one for the setback for the rear.
And for the reasons to set forth in the staff report.
Set forth in the staff report as elaborated on in our discussion. Is there a second?
Second.
Been seconded. Please call the roll. Yep.
Mr. Wyatt,
Yes.
Mr. Chapin.
Yes.
Mr. Des George.
Yes.
Mr. Russo.
Yes. So that has been granted. Second variance has to do with the setback on the side of the garage. Is there a motion to grant that?
I will
variance?
move, but this, I want the record to make it clear, this is not a precedent setting matter, this is unique to these facts in this particular property location. If that could be in the record too, I would like, I don't want to have it.
It'll be reflected in
Wait.
the minutes.
Wait. So there's a motion to grant the variance for the setback on the side for the two-car garage. Is there a second?
Second.
Second. It's been moved second. Please call the roll.
Mr. Wyatt,
Yes.
Mr. Chapin.
Yes.
Mr. Des George.
Yes.
Mr. Russo.
Yes. So both variances have been granted. Congratulations. So.
Thank you for that hard time.
That's
That's
out of our- that's out of our- okay, we're out of,
Well, so if we go to just matters of general concern for the BZA. Okay, so, Phil and I have had some conversations, and, there has been, from the previous board, the BZA, a piece of the case has been remanded for the second time from the 12th district and the trial court. And, kind of looking at past practices of the Oxford BZA, other past practices in other practices in other communities. So the quasi judicial process is unusual in the sense that if this were in a courtroom, and you had a criminal or civil case, the deliberations would never occur in the public forum. And there's many practical reasons for that. If jurors, which functionally a BZA there's a quasi judicial function. You're serving as jurors who listen to evidence and then take that evidence and apply the facts to the code. Not as lawmakers, but think of the BZA code as kind of jury instructions. What you can even imagine the appeals that would happen is people would say what they're thinking to ask questions, sometimes rhetorically, sometimes challenge the assumptions of others. And it's very easy to, I think, ascribe intent that is otherwise not reflective of what the deliberations really are doing. In addition, as a volunteer body, it's not a group of lawyers. They're most of the time lay people who are volunteering to serve their communities. And one of the things that came up in the conversations with Judge Faith in Butler County in these cases, he was asking questions about it. He was troubled by the lack of, I think, clarity is not the right word, but the some of the chaotic nature of the deliberations that can occur in that setting. So the Ohio law is pretty clear that in the case of TBC Westlake versus Hamilton County Board of Revision, that quasi judicial bodies are exempt from the Ohio Open Meetings Act. Clear Ohio law, no question, not subject to challenge. Oxford, I suspect, has had a history of having the deliberations done in public for a variety of reasons. One, I would guess, pure speculation on my part, is in communities where the BZA denials could be appealed to the council. Some communities do that. Having the deliberations occur publicly would be beneficial for the body that gets to consider the appeal. In that case, BZA to council. So I can understand why certain communities might not have quasi judicial deliberations in private. Now, I think that one, you still have to come out with your decision standards. You still have to apply the facts. You still have to issue a decision, much like a court would do. If any of you are familiar, been into a courtroom at a bench trial, for example, judges will often listen to the evidence and say, "I'll take the matter under advisement and issue a decision." Something similar like that would happen. I think BZA would come out, announce their decision, say on the record what some of the factors they were, then there would be a written decision that would be adopted at the following BZA meeting, and then that would be the final written decision that would be coherent, concise, and would make a much cleaner record. So it's my recommendation that we amend the rules of BZA, that I provide for some language that allows the option of the BZA to go into private deliberations if it so chooses. It has the option, much as it did today, that in some cases, if you feel that they're so clean, you could do it upon motion and second in an open meeting without private deliberations, but it gives you the option, and I think it empowers a more robust discussion, a cleaner record. And the BZA does have the power to, you get to make the rules for the process, the procedure. You don't get involved in text amendments.
Right.
But you do get to create your own rules. So Scott, you're here is probably somebody who attends more BZA meetings than anybody who's not a member or staff. You may have some interest in that. So I want to give you notice that this is coming down the pike. And
Is this something that's happening statewide because of this case?
No, I think
specifically here.
No, I can tell you in another community I represent, the BZA denials are taken to council. And I've been involved in my issue is the law director. I'll be blunt. I get involved in the litigation, and the litigation is really, really messy, and it's expensive to the community. And I think that for all parties, it's just better to have a clearer record that you don't often get when you have public deliberations with people throwing out ideas. The other concern that I have is the 12th district has been very clear that the BZA is not permitted to consider information that is not introduced into the record. So if somebody says, I remember when this is the reported case, that in the Oxford BZA many years ago, someone said, well, I remember a variance that we had granted years ago. Well, that wasn't in the record. That was not evidence. So it couldn't be considered, but it was clear that it was considered evidence. So I have a recommendation, the BZA gets to decide it, should be subject to public input. And, what I intend to do is revise, I'll work with Phil, we'll draft up a new set of rules. We'll circulate that by email in anticipation of the meeting. It will go into the packet. BZA will get a draft independently. Do not email back and forth because that would be a potential violation of sunshine law. That would be a sunshine law violation because you can't deliberate outside the public setting, but you can get copies, do your own due diligence in anticipation of the meeting. The public will have access to the packet for purposes of a public meeting and notice on the agenda. And then you can make the decisions on you think is appropriate, given the purview of the power that you've been granted by the charter.
So, thank you, Chris. So that's a heads up that we're moving from a practice to a policy that will deliberate in private. We'll still make decisions in public. And the
We will
importance-
announce them, much like the Supreme Court.
Having been on a board for like 11 years, school board, I can't imagine not doing it in private. Personally.
Well, the deliberation.
And the deliberation,
The
right, you
deliberation.
come out and make a decision,
Right. Well,
but the deliberation, I think, absolutely should be.
so Chris will be preparing that packet. We'll take that up. And we have that ready, just a heads up to everyone. Any other business?
Scott, if you would like a courtesy copy in advance, I'd be happy to provide you one.
I'm not just to this BCA a lot, I'm to other BCA's a lot, and I've never seen a closed deliberation, not even out of Butler County. The city of Oxford, not Westchester, not anywhere.
So you tend to see it more in Columbus has always done it that way, because I spoke with their former law director, and I worked for Franklin County. And I know that in townships, they routinely do it. I think there's community process that people are accustomed to. I think that sometimes in BZA cases, it's clear that a denial will potentially lead to litigation, and so there's consequence to that too. So there's I think just practical realities to it. I don't think it'll happen in every case because you'll have the freedom to choose how to handle it and then err on the side of private deliberations if there's any substantial questions. And I think it allows individual members of BZA to ask questions that in a public setting that may not ordinarily be asked because this can be rather technical at times. Yeah.
Any other business before
I just wanted to mention, Mr. Chair, we don't have any cases for next month, but if you did want to meet concerning this amendment to the bylaws.
let's check everyone's schedule first. And
My vote would be August.
yeah.
Vacation coming up in July.
I think I'm out of town then.
Okay,
In July.
and if you wish to announce the cancellation of next month now, if that's,
Well, let's first find out whether or not everyone is.
Okay.
Is available for a meeting.
Well, Chris, are you need more time?
It's Friday.
Friday.
No, I mean, I can, I've got this
We
document.
need more time to get that. Yeah, that might take a while to draft it up.
Not really.
A procedure vote like this is the reason why we all have to meet. Is there any reason why we couldn't do this virtually? Is
Yes.
the procedure?
Yeah, sunshine law requires you to meet.
We'll meet and do
We're not, I don't think they allow virtual meetings. Yeah, we don't have that.
it. If we have to schedule a special, we can do that as well.
it was only during COVID.
Only during COVID.
Yeah, especially.
We could.
But the deadline
I
for
think
any-
the
for any
procedural
July
thing.
cases.
Last week.
Friday,
Oh, so we have
no cases
for
for.
fraud. Yeah, we just need
I
to.
mean, I don't think it's critical that we have a special meeting to adopt this. It would have potentially changed a longstanding practice within the community and that merits thoughtful discussion.
Right, and that was my concern. Practice had been a policy and now we're changing policy. So. All right, was there a motion to adjourn? Moved, second, all in favor,
Aye.
opposed, abstentions, we're adjourned.
I love you guys.
Thanks, everyone, for your consideration.
Thanks.
All right, I don't see anybody for the rest of the summer.